Good morning. I am Kevin Price. Delighted to be with you. Going to spend some time talking to you about you and your business. Got a lot to talk about on today's program. I'm going to get straight to it with Hessam Parzivand, and he is a regular contributor on The Price of Business, but you've been all over the place. You're a hard man to find these days, and it's because you got just really exciting things going on with your firm, which, by the way, Parz Firm, that's PARZFIRM.com is the best way to learn more about you and your practice. But congratulations.
Thank you. Yeah, it's been a little hectic recently. I traveled to Flint, Michigan for a deposition, and also to San Diego for a deposition, and have a hearing in court tomorrow as well.
Yeah. Well, congratulations on that. And better to go to Flint in October than December. So,
I agree.
Having grown up just south of Flint in Ferndale, I know exactly what it's like there. So, tell us first of all, before we get started on our comments and on your focus today, which I think is a very practical focus. I'm excited about it. I have a question from a listener about a very important topic. We need to talk about that briefly as well. But also, I want you to tell a little bit about your practice, just so the listener can get familiar with what you do.
Sure. I practice primarily in the area of labor and employment law. I've been practicing in this field for about 5 years now. Before practicing in this field, I got my degree in human resources, and I also hold a professional in human resources certification. I do practice on both sides, both for plaintiffs and for employers.
Mm-hmm. Very good. Now, do you want to talk about your topic first, or do you want me to ask my question first?
Go ahead and ask your question first.
The question I got from a listener is, what do you suggest when it comes to putting together an employee handbook? Because this is crucial. I'm telling you, your relationship, if you're not in a contractual relationship, 1099 relationship, if you're going into a W-2 relationship, it's full of peril. You better be ready for that. And so, and that's really the best protection may be your employee handbook.
That is true. The employee handbook has a lot of policies that are very important legally. I'm not going to say that they aren't available online and couldn't potentially be copied, but I do think that it is always best for an organization to consult with either an employment lawyer or an HR consultant first, on employee handbooks, and also, no matter what you find online, it will not be unique to your business. So, for example, if you have drivers, you definitely want to have a policy regarding no use of cell phones while driving, just to cover yourself. But there are a lot of unique safety related things that are very business dependent.
Yeah, and no matter how much you try to do it on the cheap, you better make sure you have an attorney sign off on it, because if a legal issue comes up between an employee and an employer and it leads to court, the very first thing that's going to be asked the employer is the process that came into creating, or one of the first questions, what was the process into the creation of that employee handbook? Don't you think?
That is correct, and sometimes employers do get in trouble because they have too much in the line of policies or are not familiar with their own employee handbooks. And just to give you a case example, case I actually filed yesterday on behalf of an employee, the company, or in this case, or the defendant, had a policy regarding complaints, and the policy required them to, before writing up the employee, actually tell the employee about the complaint. Well, my client got fired without hearing anything about the complaint.
So they violated their own protocol.
Right, they violated their own protocol, and it looks really bad whenever I bring a discrimination case against them that they can't follow their own written policies when they're, in this case, claiming that my client got fired for violating an unwritten policy, but they're not following their own written policies.
Yep, you got to watch that. Talk a little bit about your topic today, which I think is really timely, which is social media in the workplace.
Yeah, so it's social media is obviously, you've got a lot of blurred lines with social media in the workplace, and a lot of people are even being asked to use social media to promote their workplace. I have friends who are lawyers whose firms actually tell them to post about their jobs on occasion as a matter of promotion. General rule for employees, don't use social media to talk about work. And you'd be surprised, even positive things sometimes can get you in trouble. Good example, a waiter posted about Peyton Manning's tip to him, and it was actually a rather substantial tip on Reddit, and he got fired. So watch out, even on the positive things, if you're going to kind of invade somebody's privacy or something to that effect.
Wow.
Watch out for that. But obviously, on the negative things, you, as an employee, you definitely have to watch out, because if your conduct does not fit into certain protected categories, you're completely unprotected for your social media post.
Yeah. Thin line between Peyton Manning is a super generous, nice guy to this is how generous he was. People don't really want that on display, and I can even understand where even Peyton may have been miffed by that. He probably, he seems like a class guy. He probably didn't call, didn't complain, but the owner look at that and go, you know what, there needs to be some discretion here.
Right.
And this is the antithesis of that.
Right. Oh, I would agree. And I mean, I think especially, when you're dealing with a celebrity issue, even if it's a positive celebrity story, that's still an invasion of that person's privacy, theoretically speaking.
Should even an employer's handbook address social media?
Yes. Employer handbooks should to some extent address social media, but there's a huge quagmire there. And that actually leads kind of into my next issue, which is that the National Labor Relations Board is seeing social media as kind of the new I guess water cooler where unionization talk begins at its kind of embryonic state. Mm-hmm. And as a result of that, my general rule for employers is don't jump the gun and automatically fire an employee because of their social media posting. Definitely focus on whether that social media post regards their working conditions. So, for example, if an employee posted on Facebook and said, I think I have an unsafe workplace, and let's say that employee has multiple friends who also happen to be coworkers, that firing that employee arguably could be in violation of the National Labor Relations Act, which prohibits unfair labor practices based on concerted activities of employees.
Wow. So it's a really dicey world out there when it comes to this type of thing.
It is. Unfortunately, a lot of employers are getting shocked by this. And another important thing to note, a lot of people think, hey, if I'm under 15 employees, none of the laws apply to me. The National Labor Relations Act is one of those laws that applies based on revenues, and I can't go into the individual revenue thresholds, but I would say it applies to about 99% of businesses.
Wow, that's interesting. And it seems like the push is to get more and more businesses under those guidelines.
The National Labor Relations Act's been around since 1938, but yes, and I've never seen any kind of law change recently to, like, let's say push it down from 15 to 3 employees or something to that effect. But I mean, 15 is usually your kind of magic number for purposes of discrimination laws. Your next kind of threshold after that is 50, where the Family Medical Leave Act begins to apply, and as you know, Obamacare also begins to apply at 50.
Absolutely. Have you had any lawsuits that directly pertain to Obamacare yet that you've been involved in?
No, I haven't. The only thing that I can think of that may possibly be something that I would do is because I don't do as much in the line of employee benefits. Is there are some anti-retaliation provisions under Obamacare. So, like, for example, if an employee steps up and says, I want insurance, or I want to go to the exchange, or something to that effect, I think that there are some anti-retaliation provisions. But it's been a long time since I've reviewed those, and they have never come up in my practice so far.
Interesting. I think, I love what you bring. I love what you do for our audience, and I think it's so crucial for both the employee and the employer to have people in their corner with your kind of experience to navigate them through. Any last thoughts as we wrap it up of things that you're seeing that might be a future story that's going to be important to our audience on the business law front, on the employment law front?
I'm just trying to think if I've seen anything. I can't think of any major headlines recently that struck me as kind of generally applicable to employers. So I think we'll leave it on that note.
Yeah, but I think that it's an interesting. Our producer is showing Urban Outfitters are asking employees to work for free during the holidays. We'll let you read that article and comment on that in a future show.
Thank you. Yeah,
we definitely need to do that before the holidays.
It's definitely a violation of the Fair Labor Standards Act, almost definitely, and probably state wage and hour laws as well.
Yeah, they're like the honey badgers, of business, though. They really don't care, So I'll use different language, but instead I won't. But Hessam Parzivand, he's a regular on The Price of Business. Parzfirm.com, P-A-R-Z firm.com. Keep sending your questions, info@usabusinessradio.com. We'll have more for you, by the way, in the future. We look forward to hearing your answers.
Thank you, Kevin. Thanks for having me on the program.
When we come back, more for you right here on The Price of Business.